Hello, I'm Michael Lutman, Chair of our Think House events, and I'm here with our co-founder David Lowe, who's going to be bringing us up to date on contractual matters. David, Mike Ashley, sports director, and his power drinking, he's been in the news, so what's he been up to?
It's great, isn't it? Contract law is on the front pages of the tabloids, and of course we've all been diligently following the story because of the contractual law implications, and nothing to do with stories of him vomiting into chimney places and how he can drink 14 pints. But yes, it was a contract law case, and it's quite interesting how the judge came to his judgment and issued it within 2 days of the conclusion of the case, which shows that he was able to quickly form his view on the legal merits. It was all about, well, was a contract formed? Had the Mr. Blue entered into a consultancy contract, which if he raised the Sports Direct share price by a certain amount, he'd get paid tens of millions of pounds. We'd all know the challenge of that. A verbal contract is in theory possible to be a binding contract, but you've got to prove it was said, and of course everyone has different memories after the event. But to be fair to Mr. Blue, he was able broadly to prove, even though Mike Ashley had no recollection of the conversation, possibly due to the amount he'd had to drink, but other people in the room were able to confirm that this conversation happened. So he was able to clear hurdle one, that this conversation actually had happened, but he fell over on intention to enter legal relations. Court said you can't expect to be in a pub drinking lots of beer and think that you've just created a contract when you haven't even bothered to write it down or there's been no serious attempt. Although everyone recollected this conversation happening, they also recollected how they laughed at the proposal. And he just said there is no intention to enter legal relations, therefore there is no contract. Mr. Blue, you lose and you pay the costs.
All I can say is thank goodness for that, reflecting on a few conversations I've had in the pub lately. But these cases on contract formation, they're still quite common. What lessons can we learn from them?
Yeah, so the Mike Ashley case is not one that's going to trouble any of us. None of us would seriously expect that to be a contract. What is really worrying is that every year when I review the contract cases, there are lots of ones where lawyers have been involved, where contracts have been negotiated, haven't quite been finished, and then of course there's a dispute and there's an argument, well, do I have a contract at all? And if I do have a contract, what's in it? So, you know, we had yet another one of those this time. It was a building case where the court said, well, look, there's lots of different terms and conditions washing around. I think you've got a contract, but these terms and conditions, I don't know if any of them apply. So it just comes up again and again every year. There's an estate agency contract where the estate agent agreed the commission, but he didn't agree what the trigger was. When did he get paid? On exchange, on completion, some other date? And the court said, well, we're not going to fill in the gaps for you, and therefore the whole contract collapses. So it's worrying, isn't it, that businesses who are doing what's really important to them, creating value in their businesses, entering into contracts to secure that, but aren't seeing it through to making sure the contract is closed. What's really important is for people to realise that it's better to have a contract in which you've compromised a bit to achieve finalisation than to not have a contract at all. And people need to take them seriously and bring some pace to it to close them and compromise them.
Yeah, you've talked about when contracts are formed, but of course, even when they are formed, we have issues of interpretation. Now, of late, we've had some view that we might be drifting towards a more purposive construction. So where are we on contractual construction?
Yeah, so we've had a series of Supreme Court cases over the last 5 or 6 years where some of them are going, no, it's the words on the page that matter regardless of the outcome. While others said, well, hang on, you need to just look at the context and go, what was the intention? What does the contract say? And so the academic debate has been, are we becoming more purposeful or not? We've had a case this year, Wood and Capita, it was all about an indemnity in a share purchase agreement, where that question came up. I won't bore you with the facts, but if you understood the facts, you could understand why the indemnity just didn't quite work, but you could understand what they were probably trying to achieve. And so Capita saying, come on, court, you knew what we were trying to do. We should get the benefit of this indemnity. And Wood were, of course, saying the opposite. And the court said, it's not about text or context. These are things that together you take into account, and it's the weight you give to them. And they said, if it's a sophisticated contract in which lawyers have been involved, then you're going to be more inclined to look at the pure words and ignore the context. While if it's an unsophisticated short contract with no lawyers involved, then you're going to be more likely to take out the broader context of the agreement. And therefore, in Woods and Capita, they sided with Wood and said, no, we're going to read the indemnity exactly as it says, the words on the page. I'm sorry, Capita, we can see that's probably not what you intended, but that's the words on the page and we're going to stick to it.
That sounds to me like a very common sense approach, but of course, sometimes even common sense doesn't get you into the right place. I seem to recollect we had a case recently about fit for purpose and a specification and how the two fitted together. What case was that and what was the outcome?
So that's the E.ON case. It's all about wind turbines, offshore wind turbines, which have been built and weren't fit for their purpose of operating for 20 years at a certain maintenance cost. The consequence of that was a cost of circa 20 million euros. And it's gone all the way up to the Supreme Court. And it was difficult because in the front of the contract it said, we want this kit to be fit for its purpose for 20 years, while hidden away in the specification is a reference to an international specification. And there was an error in the formula of this international specification, which nobody realised until the wind turbines went wrong. So the court was faced with, well, how should we read this contract? Should we read it narrowly and take the specification and take this standard, which although it's wrong, that's what they contracted to supply and they did supply and therefore E.ON should pay? Or should we sort of look at what the overall point of the contract was and take out this fitness for purpose? How do we read these two things against each other? And the outcome was the court decided that the fitness for purpose trumped the standard. They said when you read it all together, that fitness for purpose 20 years is meant to mean something and it shouldn't be sort of held back by a detail of a formula in international standard which has gone wrong. That is a risk for the contractor. So what are the lessons there? Well, there's a sort of basic one is trying to reconcile your various parts of your contract to come up with one single specification which can be read together. But in these contracts that's hard work. There's often complex specifications of different scattered throughout the agreement. It is, of course, an issue in any capital equipment, the tension between buyer who wants an output and seller who just wants a clear specification. So as a buyer, be conscious of that and make sure that if you want a broad specification, you make that really clear. And I think, reminds the suppliers that, the contract could well be read against them. They are the supplier. The court in this one said this contractor takes that risk. So suppliers, don't be sloppy with your specifications.
So some interesting cases there. What would be your sort of top drafting tips coming out of those then?
Well, there's been some cases that I think probably worry me sometimes. That was one case where the term practical completion was not capitalised. So throughout the contract it had capital P, capital C completion, and a couple of places it had lowercase practical, lowercase completion. And the court said, oh, it must mean different things, because if you meant it to mean the same thing, you would have defined it. So, basic tip is just check your definitions, check that you've got defined terms and use them all. It's a quick check to do. There's another case where the table of the KPIs had been missed out, but the example table of the KPI saying this is how everyone expects them to work was there. And the court said, well, you might have missed out the main table. Well, let's use the example table. Again, if only the table was in there in the first place, they wouldn't have even had the dispute. These are things that are within our control. I mean, there's many cases where it's out of people's control that something's gone wrong. The E.ON case, we can discuss lessons, but it's out of the contractor's control something like that happen. But making sure the definition's there, making sure the KPI table's there, are things that are in our control. And I think that's probably a key contribution we can all make.
Good old basic stuff, really. But what's not basic, of course, is consequential loss. I remember having cold sweats when that came up at my lectures. Any developments there?
Yeah, so I think with the case law over the last 20 years, we've come to a settled view that when we refer to consequential loss in a contract, and most importantly exclude it, is that what we're excluding is indirect loss. And that is the second limb of Hadley and Baxendale, loss which is quite remote, a party's not going to be liable for unless there's special knowledge. NEI Power Projects and British Sugar was the 1990s case that settled that. Consequential loss isn't loss arising as a consequence, it's just indirect loss. But we've just had a recent case, it's a shipping case, where there was an exclusion clause, and wrapped up in the exclusion clause was a reference to excluding all consequential loss, and there was a debate about whether the exclusion clause should be read narrowly so that it only excluded indirect loss, or should be read more broadly. Now, anyone watching this will be thinking, well, it should be the narrow definition, but actually when you read the particular clause, it set out a series of exclusions, of which the consequential loss was a sort of final one. And when you read the couple of sentences all together, you can see that altogether they meant, clauses 1 and 2, this sets out the caps and controls and liabilities, the limits on liquidated damages and all that. And then the sweeper clause was making clear that you're not liable for anything else. And so therefore the court in that case said, you know what, we need to read consequential loss a bit broader. So it's a real reminder to us all that although the principles are quite clear, how you use the words and how you build your liability clause is really crucial. Which takes you back to the wooden capita. What do the words actually say? How do they all stick together? What you're creating is really important.
Moving away from contract words itself, but more into contractual practice, I see the government's trying a bit of nudge politics in this at the moment. But many companies are going to have to disclose their payment practices. Can you tell us a bit about that?
Yeah, so it's been a long thorn for 15 years. 15 years we've had late payment legislation that are meant to try and encourage people to pay when they said they were going to pay and to pay quicker, and it hasn't worked. And it's a difficult issue. Should businesses not be free to contract on whatever terms they want to, while the small business lobby says, hang on, we're the small guys at the end of the supply chain, we get done by this. The government has been urged to legislate to force everyone to pay quicker, and obviously that caused lots of concern. So they've come up with this different approach, which is we're not going to force you to do anything other than report on 0 to 30, 30 to 60, 60 to 90, what proportion of your debts do you pay in that time, and allow the world out there to make their own decisions about the kind of companies they are. And so, as you say, to nudge right behaviours, use power of reputation. Look, company X always pays more than 90 days, but company Y in the same sector pays in 30 days. Why is there a difference? And allow it to become a PR issue. Some might call it nudge politics. Others might say the government's abdicating its responsibility and leaving it to the sort of the press to determine what's appropriate. For all of us, though, for any in-house lawyer, what this creates is a bit more admin, primarily finance admin, but no doubt you as in-house lawyers will be asked to check and make sure the systems are right. So more compliance, unfortunately.
David, capital D, Lowe, capital L, thank you very much.
Thank you.